We aren't reading a plan in this debate, though, so that'll be interesting.
Is it new on paper?
No, because they didn't wake up to print it out.
No swarms. Fair enough.
Okay, the swarms thing was fine.
I liked it. I'm just saying if you guys are reading it again.
Oh, no, it's new.
Oh, got it. They just didn't Oh, that's funny.
I mean, the swarm thing was, like, dumb, but not as dumb.
I liked it.
Yeah, it was, like, fine.
No, that was actually surprisingly good.
I was telling Arma,
Right.
Arma didn't believe me. Thought I was kidding. I was like, no, I'm being genuine. Like, I thought it was good.
The we meet on AI. It was
Oh, yeah.
like swarms are strong AI or something.
Yeah, the problem is they don't, like, read the file, or... Yeah, those cards are good.
I also was like...
That psycho who's like, we should adopt a rights of nature approach towards swarm AI intelligence. I was like, this is fucking dumb, but underline.
I also like...
I was like,
I was
F10.
like, I think Banky's gonna kill you for the perms you wrote. Because Banky's who told us in his R&D to write like XYZ perm against this
I just didn't think you were going to take Michigan's curbing counterplan, so I didn't write a 2AC block to it.
No, yeah.
But that is super funny.
Fair enough.
I mean, they would say no.
Yeah, that's
But, yeah, the other thing, it was fraught. It was fraught.
Can you get your opinions again?
What's up? I've eaten one bite, and, like, I'm going to continue.
Okay, fair.
It was, like, free and close, and I got a judge, so.
You should,
What round is this?
you should, listen. Interact with me. The round? Oh. Of course. Same thing that you could. Let me know.
Are y'all debating though, right? Is this a debate?
Yeah, it's a bit.
Now we're just prepping, bro.
Yeah, we're just sitting around.
Was that a Georgetown debater that asked that?
The data.
They're funny. They are funny. In their own way. Okay, when is this set? I really hope they're cropping all these like YouTube videos. I feel like I talk shit before every single one. Okay. Did you all get it?
Yeah, I got it. It's opening right now.
Okay. Do you have it, Binky, or?
Yeah.
Okay.
Yeah, I don't care.
Mine is still like
Fair enough.
saying like.
No, wait, don't worry.
Okay, I got it now.
Okay, sounds good. Advantage one is innovation. AI innovation for health around the horizon. Development and standardized liability practice for its application is key. That's really impaired. 22 liability unprepared for AI design for humans' mistakes. liability punishment on the end user and errors occur without human impact. Liability harm patients. Liability as AI becomes underregulated. AI promises to revolutionary liability rights, essential to unlocking potential and conflict litigation, discourage investment, development, and adoption of AI in healthcare and our credibility to everyone else. Face it, they encourage adoption and critical in establishing responsible use of AI. AI aided diagnosis, research, predictive analysis, and focus on the end user. End users will avoid AI if they bear a liability for failure or shifting the blame doesn't solve, and no one can be sure how an algorithm will arrive at a conclusion. Anything else broadly dampens investment in medical AI applications. That's a Conclavis 18 specific rules foster a professionalization, making AI more responsible and transparent and clear. Liability generates safer technology. Manufacturers compelled to avoid technical failures. Technical liability rules lead to increase in safety and ensure recovery from harm, and clear rules must be established to avoid uncertainty has an adverse effect on investments in uncertain actors. Incentives to investment into open robotics, leaving robotics underdeveloped. The plan guarantees AI is developed safely and effectively. That's Chapter 22, modifying liability violates short law imposition in absence of negligence or control. Strict liability manufacturers not situated in to prevent accidents and caused by AI's decision making and underwriting justification for applying liability will not result unless accidents does not translate when AI performs tasks better than humans and design tasks to AI will prevent accidents and build and improve the performance of AI position itself in liability causing medical errors and discouraging automation in favor of less risky AI when AI is safer than humans. That's key to precision medicine. That's Chapter 22. AI tools catalyze precision medicine, tailored intervention, and presented specificity and assessing insights decisions, understand medications impacting persons' decisions about the future. AI powered analytics and drive precision medicine predicting behavior and tailoring interventions, personalizing resources allows sites to be proactive and personal. It's the critical internal link. That's easy. 19 medical field is committed to delivering evidence-based care. Evidence use does not always account for tailored approach and contribute to less optimal prevention strategies. Advances in the use of precision medicine will have a positive impact on voluntary readiness and performance objective to harness weight and personalized approaches to optimize, including ensuring medical readiness and return to duty related to military relevant mission progress. Perception of weakened military readiness causes Russia and China wars. Polymeropoulos 22 deterrence is about shaping behavior to convince adversaries that the cost of their hostile activities outweigh benefits, and deterrence relies on full spectrum of messaging and biomedical conventional military action. China and Russia are unique challenges. All out war would devastate the economy and multinational business. China is the nation on the rise that feels it deserves a place at the top in Russia. Focus on ways to look strong in regional audiences. The message and game and deterrence depend on adversaries' perception and capabilities and intent to use them in impression that if the adversary were to challenge in the United States could cause enough damage to outweigh any gain of a deterrent threshold. Is evaporating adjustments that must be made. It'll quickly go nuclear. That's so strong. 22 regional crisis of Russia, China, with nuclear weapons if they proceed. The conventional loss would threaten the regime of the state. Extinction. That's 122 nuclear weapons in the army of the U.S. Russia and China hang over our heads like the sports of Nemesis and the effects of full scope. We're using strategic nuclear weapons. The sky will be blazing. The irradiance of 1,000 tons, and the cities and forests will be incinerated. And insurging black clouds. Our planet will become an inhabitable. Personhood is key. That's China 17. Washington should be classified as a legal person approaching liability without clarification of AI cases. Prompts to become longer and costlier on litigation focused on who to pursue rather than the merits of the case, and if decisions deny responsibility. Limbo where it is uncertain who is involved in the patient's care, making attribution difficult, allowing Watson to be a party for a party proof its involvement, establish who elevated deviated from Watson's recommended treated as a person, and claimants understand Watson's role in fault 8 tiers, making determinations and ensures hospitals are not disincentivized from employing AI. Tech calls for oversight and provides practical fault-based regime and insulates manufacturers predict unpredictable consequences. Then with Watson's legal status speaking, clarified parties get clarity, classification, circumventing essential analysis of what Watson represents does not mean an upstream of intelligent AI is eminent and merely entities that are accountable. The standard for litigation creates impossible burdens of proof while the patient holds any other parties liable. That's C21. The malpractice vicarious liability under respondents to be sued against the companies and present issues when applied for medical AI because we're law based around 2 things: black box AI box. Patient must establish a decision no to duty and patient and breach that duty. Patient sustained damages and breach was the cause, and without being able to prove the plaintiff not bring a successful claimant holding a doctor responsible because he's unique problems as trials become complex and ever evolving. Standard creates uncertainties in situation where a physician held liable for failing to use AI under respondent superior and have serious consequences. The hospital is deciding to purchase AI equipment and risk of original pregnant or adopting new tech event. Things that will put the bill in the created environment where hospitals hesitate to invest in new tech and for fear of litigation and mistakes of litigation and provide effects on hospital practices. Doctors are risk averse to fear of litigation, all medical tech and products liability, and hesitant in applying to encourage innovation and prevent parties from determining fault by limiting admissibility, allowing manufacturer to escape product liability. Manufacturer remote learned intermediate as a defense to liability. Advantage 2 is trust. Successful uptake of AI in healthcare settings depends on patient trust. Explainability and justifiability are key. That's up. Zoo 22, the black box AI promise to revolutionize healthcare drug discovery to treatment medical field is trust-based and opaqueness of black box AI proven to be problematic since neither patients or clinicians can ask questions about the decisions. It becomes difficult to see AI without explanations. Doctors refuse to believe the recommendation medical programs suffer from distrust and explainability and justifiability. In order to allow AI to reach full potential, you need to open up the black boxes, develop methods to ensure trust. The plan solves by holding AI decisions accountable. That's a for 22. AI physician will make mistakes and injure patients, and the mistakes occur in the AI's unpredictable deep learning process. The human decision making lack transparency, have a poor explainability. The AI capacity to make wrong decisions cannot the predicted manifest human-based quality of the AI physician unpredictability now serves a barrier to uptake AI physician. However, it must be accountable when decision-making bridges the legal standard of care, only addressing consequences for black box decision-making can solve Sangani, Kadari, Emory, 21 AI health applications of behavior adoptions, consumer trust, medical AI less and cannot hold AI accountable. Consumer adoption has much to do with negative perceptions of AI care. Do not believe they understand how AI makes medical decisions. That view its decision begins a black box, and understanding how a derivative decision has manipulated, understanding how AI made decisions was unaffected by explanation because had already felt the letter was a black box, but this is limited understanding of decisions made by providers. The plan solves the black box problem by allowing AI itself to be held liable. That's step for 22. The person for autonomous decision indirectly liable for negligence liability eliminates unfairness and imposes a liability on humans on a result of better AI decision or safer care and decreased uptake. And direct liability allows a physician to be named a litigant and enabling participation in discovering and validity of file claims for determining why errors occurred in the party to litigation and produce information that might be otherwise privileged. AI has the right to request discovery, gives physician an opportunity to expose negligence through discovery and claims, ensure all parties are involved, crucial for accountability, prevent contested picker pointing by human defendants and trying to escape liability for their negligent actions. Common occurrence in medical negligence, eliminating the parties' ability to access organs and checks foundation for all limited personhood solves and makes it insurable. A practitioner provides a defendant and help to pay legislative costs for AI physician mitigate the liability risk and uncertainties, increase the uptake of beneficial AI, reducing liability. Insurance companies will perform a credentialing function, reduce risk caused by AI that an insurance objective standard of care, loss liability, which has to standard behavior without facing obstacles posed by inability to explain how it reached a decision. That's key to patient understanding and acceptance of AI. That's Encompass 18 to liability tech. Allow developers to operate under a predictable liability regime in the entities without proving fault. Only damage unpredictable consequences based on self-learning or likely advantages. Does not require creation of new film malpractice. Apply avoiding case-by-case assessment and tech to identify who is the agent, and victims obtain greater access to info involving the patient's care claimants may have deeper understanding of AI and the people that led to a proper diagnosis, and the institutions will adopt AI under risk security to allow creation of critical framework advances in AI mature to a level which no human intervention is required. Malpractice rules still apply. The plan creates speed and efficiency for patients. At C21 liability addressed by person and patients who can be held liable and allowing the patient to bring a suit as soon as possible, and the patient would be able to sue the AI directly and seek redress and built-in insurance plan to cover AI to deploy AI. The insurance doctor allow patients to be compensated. Hospital pay insurance premiums and insure take care of the AI person to protect against injuries resulting from the AI thought process liability behind black box algorithms possess. That process will be simplified. AI principle have burdens on and burdens and duties ensued directly for negligence, codifying federal law, eliminating confusion, naming the responsible party is key. That's all. 05 in medical trust is important. Important for responsible intrinsic reasons in relationships characterized by intimacy, and without trust, patients not submit to examination, reveal confidence, undergo treatment. Trust sets the stage. Healthcare law concerned with punishing deterrent breaches of trust and suits is central to any inquiry and connection between law and trust and liability. Most effective ways legal system promotes trustworthiness, ability to sue, assuage the sense of betrayal result from medical error, and injured patient sue to teach the doctor a lesson in deterrence and corrective justice. Trust-based law, medical care remind law should take into account. Failure to do so undermines the AI healthcare system. It makes AI winter inevitable. That's Richards in 21. AI medicine enthusiasm continue to grow, and the patient's concern about AI significant barrier to dissemination. Importance of patient engagement ensures technologies integrated foster public trust and mitigates patient concerns, result in another AI winter, and patients are beneficiaries of their needs. Important ensuring advances are developed and implemented in an ethical way, improves patient care. Ethical obligation to ensure patient values are incorporated. That's key to every aspect of pandemic preparedness and response. Class U22, the pandemic worldwide challenge for healthcare spread with speed and intensity and prevalence of pandemic emphasized the need to investigate, prepare response strategies quickly, and BDA makes it possible to study crisis facility pandemic strategies, cover vaccines and treatments, forecasting optimization, assist in decision making. ML automates the execution of rules algorithms successfully. In healthcare makes BDA simpler, automating, enhancing data, and make data meaningful decision making. AI operations, advancement in cloud computing, and price to instant data retrieval and built with access to large repositories, big data capabilities, help stakeholders make informed decisions. Extinction, that's came 21. The epidemics running human life, and we present a simulation experiment. Certain diseases can affect all nodes of human networks and link to a human extinction. The Black Death, smallpox, SARS, Ebola affected a large population. Risk increases with immobility and threaten humankind. Extensive spread will affect every person in previous items. Coactive models, and however did not conduct quantitative assessment. We consider various disease characters. Results reveal certain diseases lead to human extinction. Thus, the plan: the United States should bestow a legal duty of care onto medical artificial computing systems.
Okay, are you ready for cross-ex?
Yeah.
Awesome. So you say a legal duty of care. I guess what does that require an AI doctor to do?
So it doesn't require that an AI doctor do anything in its application. It just says that they can be named as the responsible party when they don't meet the standard of care.
Okay, and I guess what is that standard and how is it determined?
Yeah, so it's like defined in HIPAA rules that are currently used for regular doctors. It essentially means that you have to have the patient's best interest at heart. Obviously that's vague. There's a bunch of planks added to that in the HIPAA compliance network.
Okay, so it's patients, or it's like the best care of the patient,
Yeah.
best interest of the patient at heart. Okay, cool.
Yeah, the plan does not fiat that standard though.
Sure,
It's just
but it's a
normal.
likely standard. That makes sense. If the AI violates that standard, how is the AI then held liable?
So, I mean, there's multiple ways that it would be held liable. I think because it's a legal duty, likely there would be some damages awarded, but again, the plan does not fiat the outcome of that.
Sorry, I get that. I guess I'm wondering, like, what process do, like, patients have to go through to hold it?
Yeah, so the Duffer card I think is the best explanation of that. It talks about how the plan solves the black box problem by just bringing the case to the courts, right? So the fact that the AI can be named as a defendant means the discovery is quite wide, and they can sort of investigate into the algorithm, which is all that's needed for trust.
Okay, cool. I guess last thing, so let's say someone brings a case to court, how is it determined whether the AI or the doctor is at fault? I guess, like, if in a situation where a patient, like, works with both a human doctor and an AI.
Yeah, so the Duffer evidence definitely, I think, explains how that process of discovery would work. I think there's different legal standards that are used, like contribution, comparative fault, contributory negligence. Like, there's a lot of legal nuances to what that process would mean, but in simplest terms, it basically just means they compare how the algorithm was coded and if the mistake was intentional.
Okay, cool. 14, 13.
How many was it? 4, trust, innovation.
There's a plan, but they don't know how to email the plan after you read it. So, hopefully it got read.
Oh, hopefully they didn't email it out first and then they just put in all their case shit and then it's through the plan.
Well, yeah.
Those
that's
are always the worst plans.
The plan was supposed to be to vest legal rights in non-human zombies. But, hopefully we read it and passed that minimum threshold of competence. You never know.
Okay, are we good? Alright. First up is accountable text. The United States Congress should, under its constitutionally delegated Article 1 powers, establish a specialized legislative tribunal called the Medical AI Tribunal, overseeing decisions related to medical artificial computing systems. The United States federal government should consent to the Medical AI Tribunal. The tribunal shall provide administrative redress and compensation when AI fails to meet a reasonable standard of care and competes. Legal duties are defined in Article 3 Courts Code 16, and Congress has created the duty that the violation of the legal duty suffices for an Article 3 injury. Robinson so standing to sue as an individual as a harm. The counterplan solves best, it's fast, equipped to handle technical issues, and solves court like Nolan 14. Article 3 Courts of Generalist. Congress established specialized on Article 3 tribunals that focus on a particular area of law with understanding that an expert is needed to adjudicate complex and technical areas of the law, and establishing the task force. Congress recognizes the need for adjudicated body consisting of members who possess specialized knowledge to handle complex issues. Congress established legislative courts for reasons of efficiency or cost savings. Article 3 tribunal confers to prompt continuous expert and inexpensive method for dealing with the complex of questions. Determination was expeditious form to resolve all such disputes. The counterplan reduces court law by shifting complex law into a specialized tribunal. The AFF and massively increase court law by flooding the court with new confusing cases, generating waves of appeals 7 or 9. The special courts have exclusive jurisdiction when in the fields of law. Judges are considered experts. As specialized judges are to be contrasted with judges in general jurisdiction. Courts whose cases span around areas primary benefits. Specialized courts are improved decision making by having experts inside cases, producing penny backlogs, and generalist courts by shifting select categories of complex cases. The specialized courts are more capable of dealing with the harm, just generating fewer appeals and increasing the number of judge hours required to process complex cases by having subject matters adjudicate them. Court collect has data protection cases to become from the docket daily 20. The standing rule reduces the workload of the judiciary. The appeal of the standing dismissal to the federal judge is possible to ignore data protection cases promise to be long and involved most arise from large scale research or indiscriminate data collection. They overclass sections that implicate complex technical issues. One can certainly understand why overworked judges might be eager to get such cases off their dockets. Dismissal of a special appear data consistent with this explanation in data protection cases. The greatest shifting to smart and distributed energy now data merchants by consumer trust, which is central to grid security sent off. In 22, data has become a critical component of utilities, and as grids become smarter, data is only going to become more reported every breach. Can be costly financially, reputationally, cyber criminals made utilities prime targets. Keeping data secure must be a priority. Changes are high that a breach will occur. Utilities will be permanently lost. This means a loss of hours and info, intellectual property, and more costs with ransomware or cyber attacks. Soon escalate reputational damage can be severe. Consumer side and cooperation or handle effective management of markets and terrorists and knocking consumer confidence have a devastating impact. Future energy landscape is digitalized. Smart grids, computers, and grid edge innovation and energy resources are readily ingredients. Data sharing between participants is critical to a balance made and smooth running of the system. Data must be secure. Extinction Monarch 20. But what if power cannot be restored to great failure presents an existential threat? The honest question whether we can survive assets of the great base opportunities for intrusion, infinite great failure will unleash horror stores, would close food scarcity, would fall, communication with seas, planes would be grounded water, would become a luxury, no fuel, hospitals, go dark, transaction would stop, this is only the tip of the iceberg, social chaos would reign, diseases would reemerge. Next up is decay, the absence of medical, artificial intelligence is wedded to bias and discriminatory healthcare system. AI doesn't promise better treatment, new innovations will intensify existing inequalities and result in poor care. Let's lead 21. AI systems discriminate and create unequal outcomes and socio-demographic groups. AI models harm vulnerable groups who are not represented in trained entities that's already subject to health inequality. AI tools compounding to portion and damage and disadvantaged communities by COVID inequality and discrimination manifest in design and use of AI. Discriminatory healthcare processes affect health records, case notes, curriculums, trial studies, well-established biases against patients, and the clinical notes taken emphasis draw from medical AI incorporate biases, amplify discriminatory structures, compounded social discrimination data sets, or insufficiently representative of the general public. Legacies of institutional racism and unconscious biases by developers and influences choices made in deployment of AI leading to increase of discrimination and innovation and product socio-demographic composition of those who have research and innovation that does not reflect communities affected. The sense of urgency to innovation be tempered by the need to consider inequalities, vulnerability, discrimination patterns of bias will enter AI systems, amplifying inequality, subjecting disproportionate harm. The alternatives is to refuse AI. Cats in 20 experts are invested in AI central roles at American universities play the making of AI, push forward the improvement and safe discourse on AI abuse and suspense or partnerships. The university is to start with the logic of elimination, capital accumulation, and disposition, or reconstituted within neoliberal logic versus for more refusal becomes essential. Refusal can be generative, opens opportunities for coalition and coalition within and outside the university. Refusal is granted the recognition of institutional violence. Marine communities engage not in policy but in future planning and studying with the government office cannot be institutionalized policy proposals, alternatives of being sketch. Refusal is always joining the coalitions as a struggle against AI disloyalty, models AI cerebral reputation, this would mean taking acting in reparative terms, refusing AI the concept of associated epistemic forgeries as well as the institutions that the same needs to repair communities. The debate should be about the ideological commitments of the AFF and the judge should prioritize rejecting colonial assumptions of the one to see academic spaces must prioritize rejecting racist scholarship, otherwise it will justify racist policies. Guiding 22. Exhorting scholars to make the research policy relevant, may reproduce and refine hierarchies or unequal interactions, fast making radical ideas, seek to initiate change, make people as spaces for the sake of fragments, undermining the ability to imagine real alternatives to the status quo. We can only recognize engagements that are useful to systems of power rather than those that hold them to account. The policy influences the parameters of research, policy, knowledge production, perpetuate coloniality, academic practitioner, nexus, call for repair those involved in knowledge production, but that academia need to recognize that their work is not detached from the real world, even the best indigenous scholars' work is likely to be co-opted for political ends, and that one assurance even if it is only produced will be taken as justification for more translation of these inequalities to the real world seeking to present. Racist or imperialist co-optation necessitates more open interrogations, power questioning, intelligent, accepted modes of academic inquiry requires creativity. Next up is the nearest person kind of context. The United States should require end users of medical artificial computing systems to purchase a file liability insurance, creating compensation fund for victims of artificial intelligence related accidents and kind of unsolved. Will be 20. Growth of robots being decreases in accidents, receiving the only two options for law and insurance. The legal system protects accident victims of the convenience of long delays and robot accident lawsuits require expert witnesses supposedly swapped to the various forms of insurance to attract enthusiasm and compensation fund. No fault, the compensation fund alone will present the risk to fall insurance backed by a compensation fund. We've invested in such a system will be more convenient. And for accident victims, it would make it less expensive to see compensation will lead to faster payouts and then the legal process. Next up is the DA fetal personal litigation is coming down to the Supreme Court. Refuse to hear cases now recommended 22. The court opened the door to questions about rights over who they apply to. Have for like having court to reevaluate if fetus are entitled rights. So state court can answer this only the court can as a final arbiter of the Constitution. This is the next battleground. The anti-abortion fetal person of friend. States for protecting reproductive rights while the conservative majority was able to coalesce a right row over experts have to spend rights of fetuses, and the court will take its case as the argument is more radical than not. There is no precedent that supports concept of fetuses being persons' rights and duties for guarantees the success of fetal personal litigation. 11. How can you deny the claims of the fetus when you're willing to grant precedent to this bucket of tell dramatically expand the range of such bills can be a winning strategy and pragmatic sense recognition of rights of these entities by benefit the push to create constitutional content for precedent to the fetuses is glimpse about the rights of newly created entities can take with our existing community constitutional structures approach by meaning to avoid the language of personhood altogether. Embryonic personhood causes biomedical innovation protein in 21. The impact is incurable disease spread. If embryos are ascribed personhood status, they are entitled to inalienable rights. Using CRISPR to edit embryos in form the debate human gene therapy research is not illegal. Nonetheless, the time at which an embryo or fetus humanized for reaching implications encompass healthcare of human embryos and even person that has major implications. Issue constraining research on human embryos committed different scientific progress. The trust advantage. All causes to trust tank solvency injury in 22. Concerns about privacy, the exploitation or impediments to adoption of digital technologies. Patients have concerns about data discrimination biases, valid concern for patients. Patients have misconceptions about AI in the media. Liability schemes that's making consumer trust litigation is too costly. Home Level 21. It is generally accepted that tort schemes are problematic because of adversary litigation, proof of breach, and proof of causation. Litigation takes time and resources and the adversary nature. It's not conducive to an open discussion between patients and professionals. Establishing breach can be difficult to show causation, even in cases where something clearly win. Practical challenges are significant, may be challenging to work out who's potentially involved in investigation. While these issues take time and add to the already significant cost of investigating personal injury claim. Medical AI products are guaranteed development towards the case by causing widespread disinvestment. Salvo 19. AI will be able to match the high-tech limbs by fail fast and fix it later, putting patients at risk. Regulators are doing enough experiments that AI provide for reason precaution. Since the one hospital flop into different facilities, software has been shown to discriminate. This leads to a serious health problem. VC funding is at the peak as reality is sensitive. There will be decided to disillusionment that could accompany disappointing results when AI products are ushered in. AI products have little to support. This risk will become apparent until the AI system has been used by large numbers. We're going to keep discovering a whole bunch of risk and unintended consequences of using AI. Huge tech startups publish peer reviews such self research overseas accomplishments. AI models are tested on computers on hospitals, on approved software, make patients own money, getting paid, filing fast means a bunch of people will die, nobody's going to be happy, including professors, people die, or severely hurt. Data deficiencies take medical AI, new in 21. Data deficiencies AI depend on the data, garbage in, garbage out for healthcare and medical data to record the weights of machine learning algorithms find difficult to parse US, and mismatch of handwritten notes and database entries, 71% unable to readily access digitized records to contend with the realm of extraneous information there, or a huge number of inaccuracies to read out. Don't buy up their AI sales pitch, it's all hype. It'll get worse with more data, not better, because of data leakage for issue 22. Mistakes by AI mean death reports made into optimistic picture, which translates to sensationalized stories. The technologies operating researchers feed data, however, our work identified the opposite, where accuracy decreases with increasing data size. Scientists speak known as data leakage by using the help data leading to inflated outcomes. Data leakage and publication bias are exceptionally large for models. Innovation advantage. AI innovation is not key. Their evidence about precision medicine and biodiversity doesn't mention AI once. Precision medicine is globally high and inevitable sky cost in 2023. The global PMF market has been witnessing rapid growth. Personalized treatment is found to be more effective. Therapies can be tailored to reduce cost, improve diagnostics, reduce time and side effects, and improve treatment. Its growing popularity indicates it will soon become a standard approach to treating diseases. Precision medicine is not key to military readiness, funding, technology, naval power, air power, perception of result, etc. All matter way more. No leadership impacts by less than 20. The world remained equally peaceful while the U.S. kind of forces throughout the 90s. Spending of it unrelated to stability. Africa is more peaceful. It's something which the United States hedge cannot take credit. Stability exists in many places to which hedge does not accept the ecosocial bias suggests use false speakers overestimate their own importance. So none of the contributing factors, independence, nukes, institutions, democracy, enormously poisonous. The world will continue its peaceful ways no matter what. I have 40 seconds.
Do you have another card for the K, maybe? Or for the medical AI fails? I would read a card on those two things.
Sure. Medical AI failure turns the case. Shioka 21. Expectations being set too high and willingness to tolerate failures will mean the United States co-honors AI's potential mismatch between expectations and reality can spell the end for new technologies. Opponents will find it easier to capitalize on inevitable setbacks. AI is not just too early, but will never materialize. All those setbacks.
And then, are we floating that on the trust advantage or?
Trust is probably best.
Okay.
Yeah, that much trust.
Okay. Okay, so you sent that stuff, right?
No, I'm sending it now.
Oh, gosh.
If you just open up that one and see, I put it at the end of the trust advantage. So.
Okay, I'm just waiting to get it.
No problem.
You said it was, at the bottom of the trust advantage?
Yeah, I just put it in order because I thought that would be
Yeah,
easier.
okay, perfect, I see now.
No, cool.
Oh, my first question is about the administrative counterplan. So overseeing decisions related to medical artificial computing systems. All decisions, like the tribunal from now on manages all medical AI cases?
No, it manages cases relating to the reasonable standard of care. That's the only thing we fiat the tribunal does and hears cases of.
Okay, so that's all they're hearing cases for. They're not hearing any other like malpractice suits for AI.
I don't know, yeah, just medical.
Right,
And
but for
just-
medical AI, other malpractice suits that aren't because of the reasonable standard of care.
I mean, no, we'll say they could hear. I
Okay,
mean,
so they're
someone could
hearing,
try.
they're essentially hearing all cases related to medical AI. So why would patients be incentivized to go to the tribunal instead of the courts? Do they have to post counterclaim?
Yeah, that's the only option.
Okay, that's the only option. That makes sense. So in a world of permutation, do both, right? If it is true that the courts that the AFF has are so clogged, why wouldn't all the patients just go to the tribunal and then not solve the net benefit?
Right, so this is gonna be our answer to perm do both. It's like forum shopping. So some patients would go to general courts, some would go to the article and tribunals, and that
But why?
would be.
Like, if the net benefit is true that the courts suck so bad, why would any patient take their case to the
Well-
court instead of the super efficient tribunal?
Right, here's why, because they might perceive, some patients might perceive that like general courts are more favorable to a specific case that they're bringing, or they might think, oh, if I go to this court, this district court with this specific judge, they might like find my case very appealing.
Okay, and like, what's the impact to like that one person that found some disparate?
Well, it's not just one person. Like your argument is that medical AI is going to be widespread across society. They're like you
Right, but,
can't
like,
just
I'm
assume
asking
that
about-
all like million people.
I'm
covered by
asking
medical
like,
AI
what's the
will all go to the
implication
same
of that?
tribunal.
I'm asking what the implication.
Oh, links to court clog and undermines.
But why does it link to court clog? Like, if it's like, what card do you have that substantiates any of that?
We read 2 cards about why the counterfund is better for court clog than the AFF and the perm. It's
Okay.
Mullen and Zimmer.
That makes sense. That's fine. Net benefit obviously is fetal personhood to nearest person, but for administrative, is nearest person also a net benefit?
Fetal personhood?
No, right?
Yeah, no.
Okay, sounds good. We're in front of
That's cool.
No, I'm not talking about this. Can the AI be named as the defendant in the tribunal case?
Yeah.
What does the discovery process look like?
I guess I don't completely understand the question.
Like, okay, you take it to the tribunal, how do they determine whether the medical AI or the manufacturer was liable?
Yeah, so I mean, it's like the plaintiffs and defendants would like make arguments and present evidence, and it would be a judge, a specialized judge, who would decide instead of a jury,
Okay. Wait, why would a jury decide the cases of the
because that's how it works. in
Well, no,
courts.
okay.
Sending out the tweets.
Sorry, for one of the perms, I edited the text, I'm just gonna send it. There's only one perm with a text, so you'll.
Yeah.
Okay, it was sent. Everyone's good for an order. It's the innovation advantage, the trust advantage, nearest person, the administrative common plan, the K, the DA. That's it. Is anyone not ready?
Yeah, the doc is still loading for me. Okay. It just came up for me, so I'm good.
Okay, great.
I'm good.
Precision medicine is not high to work, inevitable failure to integrate AI in the healthcare system undermines the automation of research necessary to upskill precision medicine, not strong and seek its key military readiness. Precision medicine personalizes approaches to mental health and return to duty human, otherwise there will be poor performance as easy no impact units, weak military readiness, causes war with Russia, China deterrence, depends on adversaries' perception crisis, quickly escalates when nuclear weapons based early on in capital left polyumeros, narcissism
which automated stress and collision care broadly, that's probably solving that is the largest factor for patient risk aversion of medical AI applications, identifying that AI is a responsible party lowers the risk belief for patients that do for all causes or observations about the world, that liability schemes decimate trust with the absolves of their evidence, assume the unique characteristics of AI and more liability causes patients to prioritize accountability, no failure on medical AI solves pandemics, studies the effects of crises, facilitates pandemic strategies, discovers vaccines, treatment studies, cite a successful application of AI in healthcare, makes that meaningful for decision making that's classy. And so far as it hasn't been successful, that's because of lack of use and integration. 2, data deficiencies, data status quo, the playoffs, innovation, which solves their evidence, doesn't say that makes medical AI totally ineffective, it's not hide their evidence. It's not about medical AI, prefer specificity, continued innovation, solves that leakages have no implication for the case 4, doesn't show the case. Yoko evidence is not about medical AI, doesn't assume the apps unlocking its potential. 5, robust studies prove it's more effective than gamer. And 21, AI continue to grow in healthcare field. Researchers finding new ways to utilize capabilities to disease management and prevention, especially cancer. AI is critical in diagnosing, decision making, and treatment. AI will use to improve cancer, patient care, and patient outcomes integration, improve accuracy, speed, diagnosis, decision making, better health outcomes, plan important role reducing health disparities, and say researchers, green X, 60% oncology, spending use of cancer detection, AI detect cancer better than the pathologist program, recognize cancer pathologist 4.96 program 4.98, providing more and through the manual data, it can improve data detection accuracy, AI identify pattern of breast cancer, ultrasounds, aid at diagnosing, AI tools increase ability to accurately identify breast cancer by 37%, help reduce number of tissue samples necessary for confirmed tumors by 27%, completely and accurately sort through breast MRIs. The nearest person can play one doesn't solve innovation, subpoint A fault, and the AI itself is named as dependent if it's properly for every party involved, otherwise lack of full determination generates uncertainty. That's why they see subpoint B is risk aversion insufficient to deter investment in the new technologies, the limiting threat of liability, low cause or impacts and uncertainty, magnifies the risk that states subpoint C no fault, fails eliminates innovation record, and 16 doesn't, no fault doesn't work, premiums are more expensive for actual paying costly, logically more expensive, claimants have greater opportunity to claim maximize claims, have held policy limits, complicated schemes, understood by only handful of reduce litigation of fault, have high litigation costs, the victims really left without proceeding recourse, confusing to a dysfunctional contract space of personal responsibility, accountability, fault, law, treats the about the same we can determine effect eliminates compensation, 2, perm due, but the counterplane links more than a benefit than the plane does, because it completely indemnifies manufacturer from liability, 3, perm due, the counterplane 4 doesn't solve trust away, accountability, patients, 1 accept use of AI, not because no is accountable, which underpins trust, that's down, subway B, complexity, patients need to be able to make eyes the defendant, anything else causes a rapid trace, which is critical for trust, it makes a really costly to receive damages, subway T procedure, being able to name AI as a way to lawsuit allows them to take work, discover that's key to accountability, determining error that's due for subway T, no fault, makes accountability impossible to agree, and 15, there are faults with no fault, no fault, wouldn't be other for a goal to deliver minimal accountability, compensating victim is different from assigning accountability, which entails insurance for even recognition by society of a victim and someone who's been wrong, no fault, schemes limited substitute for meaningful system of accountability made by moral principle, no fault, would not achieve adequate deterrence, retribution, place moral blame because a robot would kill someone, be held liable legally and morally accountable, gas accountability, create impunity, and have serious negative consequences. Subway E, credentialing, naming AI as responsible party forces insurance to internalize the cost of bad AI development, which road saver AI that grants that benefit that's due for the administrative counterplan firm to both if it's true the article recourse are so incredibly flooded that they can't handle another case. All cases would be tried in the tribunal system of the counterplan. Patients would also bring cases to the tribunal if the net benefit is true. Perm, the counterplan, their duties definition has no intent to define. It's a single quote from Clarence Thomas's opinion in Spokio Eaton versus Robbins case. Counterplans must be Texan function to preserve background, particularly in literature controversy, legal duties and responsibilities by law. Project definition 15, legal duty responsibilities by law. Perm, the plan to create a tribunal cover all decisions related to medical artificial computing systems is functionally textually legitimate. It feels that Congress takes all cases related to AI broadly. This specialized tribunal plan is clarification about the subset of medical AI. The second part of the perm that differs all AI cases to the tribunal. It doesn't solve the case 1 innovation. The counterplan locks corporations from the courts and forces them to the tribunal, locking them a new procedure of regulation deters usage for sure. Will go ahead with an 18 and practice coordinated relation between tech and reg is less organized, result in disconnects when new concepts are received and implementation of user pressure is brought up against what is legally allowed. 2, discovery process is key. 2, for evidence about how the court process provides key mechanisms like open dispositions and obvious investigations, which the tribunal does not know to benefit U.S. federal or state collectively. 745 U.S. United States may be used as method, maybe the name of sovereign or the collective name of the state. The third plank is just no fault, it fails as all. The nearest person can play picks or the limits and unpredictable sure you have found evidence until their offense, no computer solves against justified and then also utopian actions that can pass for solvency evidence, restricting offense not reflective of literature, protects education, conditionalities, and other present time and trust not reciprocal performance, are irresponsibility disposed, solves the Greek classes impossible seen in 22 even localized networks are vulnerable access to American providers who for complex shutdown and motion for attack data like media and access to a lot of different ways nobody is looking to her technical director at times to be company we don't think it's possible doesn't solve core clock chip and server 21 courses and things that backlog over the minute due to the lack of prosecutors, public defenders, and judges. A study suggests the system that's not moving anything along, no spillover, establishing control works better, 8.8 is overblown like imperials work, particular loops. However, I would like to emerge rules and procedures, studying the high doctrines, conserve resources such as claim, collusion, issue reclusion, attestation, joiner, and case consolidation. The assault creates legal clarity and AI innovation improves support system. Current medical AI arguments are a mess. The critique framework with implementation of the plan and alternative spending unions, so Charles Selleck, keep clash advocacy, fairness, 16 ways here, reversible death is the only ontological state, nice agency, killing everyone for others, surprise, genocide, no link in the alt fails when there's no unique answer. Evidence is about SESCO AI broadly, which is level 2, no link. The app is not about broad AI utility, rather identifies a specific demand that must be satisfied by medical AI, absent that disease, and readiness collapse or level 3 robots are better than humans. What's 22, we really worry about how humans judge algorithms. Somebody say crucial question when and whether an algorithm has flaws, and whether it outperforms for methods, it's trust, the prevailing reaction, we place a previously high demands on robots, bias, robots, is bad for humans, and yeah, no means algorithm simply better than people. We prefer humans in extreme class 4 permanently, but it's also like, can overcome links as ASCO, it can overcome the F5, they needed all robots make mistakes as anti-vaxxer, logic 6, link, turn the plaintiff's medical AI, legally liable for harm to patients, and plan insurance, people can bring lawsuits against harmful, medical AI 7, y'all can't solve, you can stop Chinese, Russian, American, AI and surveillance, 8, digital solutions are key to prevent disease, probable, and 20 digital solutions may be integrated, pandemic, volume, and interrogate how public health may be legitimized surveillance, I feel some disease surveillance, and conventional public health, the necessary tools to prevent, prepare for, and respond to pandemics, 9, AI, reduces bias, gas, 17, AFA, as part of solution 2, exposes bias, is agnostic to data, we see biases because bias humans, major tech companies have been working related bias, A, scrutinized job, descriptions for hidden bias, wrong generating, make better decisions in healthcare, overcome cognitive biases, think about how AI is a promising new weapon, 10, medical AI is a starting point that can remedy some racial disparities in healthcare, and 11, AI can be used for progressives for equity and fairness, avoiding all algorithms, does nothing to reduce bias, ignoring evidence when policy relevance doesn't contribute to empire, believe it, insofar as it does maintain hedge, that's good, we've impacted on the all on advantage 1, 2, no link to political policies to be and spill over the real world, 3, no ethical obligations to be ASG that should be centered on ethics, 5, hedging capitalism, realistic ethical system, per quantity, order justified by research makes, offensive muscles, they cross like contradictory offensive worsen that justifies severance, the personhood, DA, the absolves, and trust towards agree about 22 states, push for increasing space of human rights, and use embryos deemed legally protected for person, the embryo deemed by the entity non-viable to have no personhood rights by a lesser legal liability for clinicians, despite everything as all of the solutions of machines concerns, use the time we funded for liable mistakes by the machines, patients are elected to in healthcare, where an A becomes a trusted professional can be valuable for the entire medical industry, employing A, success, embryos, and legal determination, for civil criminal prosecution necessary, no legal plan, provides a narrow issuance of liability, doesn't confer liability for all A applications, but has a tailored made approach specifically for medical AI, no spill over 1 A, rights of legal fetal personhood, will 11 EU, deny claims of fetal or related personhood, for multiple Muslim outcomes, either expansion of rights or attempt to legislate moral quandary existence to the extent, following through the characteristic constitutional tradition, and one is that corporations are legal persons being learned something courts never articulated why courts have convened on all rights for person who is the constitution shining over pragmatically, we shall try shallow and waters logic cannot provide constitutional law which with a bridge to SCOTUS will hear a case where Pro and 22 Supreme Court declined your case court will refuse an abortion to the states and directed and issued a decision. 3 cases are contextual, showing 17 does not meet all forms of AI missing other forms of present threatening challenges and once in a while AI used by both similarly supposed AI usage context over different contexts very widely laws will have to be flexible to accommodate a very designated very responsibility casting AI laws best which are organically fit the technology not intrinsic laws to make reduce planning and very constellation protected entities fetal personhood activists are focused on Congress not the courts means they have to Congress pass the bill of car 119 abortion activists are going to be gathering but this activists will be steadily expressed Supreme Court vote alerts and the U.S. Capitol switches to lies clarified issuing for a legal into a legislative one and say this affecting results for a person that cards are likely to be persuaded for person to begin concept of question becomes our people born 9 months old all around voting drinking security driver's license and return criminal liabilities and more would have to be revived fetal personhoods and inevitable 1 states Amy 22 Alabama Arizona Georgia Kansas Missouri all person lots 2 dogs iconic 77 fees give lawyers person recognition personhood fees group and person legislation of the language personhood this likely to encourage states to law banning abortion in the name of fetal personhood 3 conservative judges have sufficient precedent they could rule in its favor if they wanted to the first 1 corporations act within the 20 non the ones already have personhood law corporations have rights to providing legal personhood to AIDS and we are in 20 awarding entities with personhood unavoidable future due to fashion based on AI technical condition really personhood in Islamic require future recognition of AI as a person limits of the functionality and social role stem cells are key to disease research through internal evidence says that it's used but not that it's key the asshole disease best AI automates and enhances data preparation helps stakeholders make informed decisions accelerates human strategies escalates precision medicine prevents biodiversity costs works in 22% equal technology address biodiversity crisis multi initiative makes critical chemical eligible food biological threats protect biodiversity for hospitals increasing significant stress to chemical embrace management individual fight individual reduce pollution precision include inherent leverage which is medicine define genetic differences such efforts improve important to environmental management because individual level represents key touching goals analogous for endangered species when across species interpolation innovation molecular design levels standard chemicals and tech advanced variable population levels responses to stressors biodiversity cause extinction there's 22 cater species are dependent on use and functioning by chemical cycles, food change, crop yield, nutrient cycling, pollination, pest control, seed dispersal, carbon cycling, soil erosion, control, animal mating, genetic diversity, related disease, hosts, infectors, plants, microorganisms, private medicine, but physical production, for extreme level, support for humanity, academic terms, value features, sector, incalculable evidence, humanity cannot survive absence of biodiversity and ecosystem functioning, which we are increasingly degrading.
How much time do we have?
I wrote it down 14:13.
Ready?
Yeah.
Theory?
Condo picks, floating picks, and I think that's it.
Okay. How is medical AI trained?
How is medical AI trained? Well, there would be an algorithm that is programmed, and I don't think medical AI would necessarily need like intensive training.
Well, medical AI is premised on machine learning. It requires a data set,
Yeah, that doesn't mean that it requires
to make
like
statistical
vigorous
generalizations. I'm wondering what is the data set for, say,
It's
a medical
for
AI used
like,
to
I can't
diagnose
tell you
breast
the
cancer?
code that's like what the algorithms
Well,
are.
I'm not asking about the code. I'm asking what we feed into the machine.
There's different statistical processes we undergo. It's obviously distinct. So for example, we have big data analytics, BDA, which we use to track pandemics. There's ML acquisitions, which we use for different things. The EPIC system in the healthcare system in hospitals. That's
Okay,
another form
but
of
you,
how
so
medical AI is trained.
So the 2AC, for example, read a card about like breast cancer radiology. What would an AI used to diagnose that be inputted with? What kind
I
of
mean,
data?
you'd likely have to create an ML algorithm because you'd have to train it in machine learning. That would then be connected to broader MRI or CT scans.
Scans. Okay, so like medical imaging. Sure.
What?
Yeah. Okay.
Yeah,
So we
usually
feed it
how
with-
you find out you have cancer is through an MRI. There's no other way to do it. We'd all die of cancer if we didn't.
Yeah, but that's all I'm asking for is just like
Yeah,
what
yeah.
are we feeding the machines? Good.
Yeah.
Okay. Why is more data good for training AI?
Because it enables better, more precise decision making.
In the
and
context
once
of racial
AI
health disparities, why is that good?
Because it enables more precise, better healthcare decision making. Like it's not different in a racial context. It's good for AI
Why?
to have more data so that it can make better, more predictive decisions. Our McNamer evidence says that enables more like precise breast cancer diagnoses.
Okay. Why does having one card about breast
We
cancer
have more than one card
representative to an entire field
It's from
of AI?
it's from someone at the Yale School of Medicine writing about broadly how people who are
I don't care where
Also,
they're
if you
from. It's just
extend-
writing about
if
a
you
really
extend-
narrowly tailored
If you
example
extend
of AI.
the K, we will read this pro card in the 1AR. Our evidence
I don't care about what
substantiates-
you're going to read.
I mean, like you should for the purposes of the way the debate's going to go.
Okay, the Woods evidence on the K. I just don't understand why we think this card answers anything. It's just like
The alternative
humans shouldn't
rejects
underestimate
AI.
robots. Period.
The alternative rejects AI that results in more unfortunate health outcomes because humans are more biased than AI. Bias against robots is bad for humans. In many domains,
Okay.
algorithms are simply better than people.
Yeah, and then that's like the only line of that card.
That's
But
not
that's
the only line of that card.
fine. Prep.
Mickey, I also said perf con, and I noticed that that was about
What's the link?
The counter plan says AI is good and the case says AI is bad.
Okay.
Did you sleep in or were you watching?
Kind of. No way I was gonna watch a debate this.
Yeah, okay.
We left the hotel like basically around when you all got disclosure.
And who's next?
Georgetown.
Oh yeah, they were freaking out about if you're gonna read new. They talked about it like the entire day.
Yeah.
You're like, oh, I don't know.
Oh, poor Georgetown.
Who's your judge?
Jared, which is pretty nice if you read new. They can't say too much.
Yeah. Oh. If you do go for condo, he hates dispo. He likes one condo.
Yeah, that's what Anna and I were talking about.
Mhm. But I think they know that too. So if they say one condo, then you can't.
Yeah.
Yeah.
But it's, I mean, if we're in a debate, we're the one
But it's one condo. Yeah, of course. Yeah.
We're chilling.
Yeah. And he obviously counts planks each as one condo. That's what saved us.
Let's go.
Whoever manages the Dartmouth Dropbox is not well.
Is there a dark?
Wait, I do want to check this one and see. It's always like something normal and then something sickening that you don't even know where they grabbed it from. Oh my god. Lazarus.
They have reincarnation answers. I love that. Oh, I guess they're D8, so they have to debate Buddhism.
They definitely have reincarnation answers because they
Binghamton,
should, because we debated Michigan saying AI leads to reincarnation.
Nice.
Huh?
No, theirs are about
In
Buddha.
the semis of Georgetown, their app is like
Or when
AI
he's
has its endless resurrection. Only the plan solves, so like you're in.
oh, like Roko's basilisk.
But then we banned it out.
Okay.
They've had a similar impact to that against us. It's like
The I have no mouth, but I must scream just says that. Sure. I love that for you.
What?
So I love that for you.
Yeah. Well, it looks like after one and C doesn't win. I do not have just everything with T.
Weird plan.
Oh, it's animals?
Legal rights to non-human zombies.
Right, but like, doesn't
Kilpatrick is a card that zombies are non-human animals. It's dumb, but it says it with that phrase. So.
okay. I sent the doc. It's going to be the administrative counter plan, the nearest person counter plan, and then the fetal person with DA.
Ugh. Whenever you're ready.
Okay. Awesome. Everyone has the doc. Everyone's good. Awesome. Instead of bestowing duties to medical AI that are enforced through the courts, the counterpart is Congress created an administrative tribunal that enforces a reasonable standard of care upon medical AI. A couple framing points. First, do not forget 1AC Crossix. They said that if AI violated its legal duty of care, patients could seek redress in the courts. And they said that redress in the courts was the critical component of AFF solvency. You cannot let the AFF walk that back on the perm to the counterpart debate. They committed to defending the courts and stake their solvency on it, and the counterpart is not the court, so they have to go for a solvency deficit. Two, don't conflate solvency with competition. The counterpart is extremely solvent, but that does not mean it's the AFF. The phrase legal duty in the resolution is a highly specific term that the counterpart does not do. Even if the counterpart is a duty in AI, they need to win it's legal, which they won't. Three, prefer specificity. Err towards highly specific evidence that compares Article 1 tribunals and Article 3 courts over the generalized competition and solvency arguments made by the AFF. First, perm do both. It simultaneously creates a legal duty of care in medical AI in Article 3 courts and an Article 1 tribunal over the same subject, which fails to solve both net benefits. benefits. Forum shopping will occur because either the tribunal or the courts will be seen as more favorable to plaintiffs, so plaintiffs will focus suits in the court while providers and those defending AI will try to appeal cases in the venue they prefer. That means cases wind up in both venues, causing mass confusion, unpredictability, and clog. Don't buy their spin that everyone will go to the tribunal. Millions of patients are set to interact with medical AI in the near future as per their 1AC, meaning there will be thousands of cases. Not all patients will have the expertise to pick the tribunal. Just because our solvency evidence says it's better than general courts doesn't mean that patients will realize that and only go to the tribunals. First, clog data. Counterpoint reduces AI backlogs by shifting litigation out of the courts and into Article 1 tribunals, adding the plan causes forum shopping and causes the courts number 9. Specialized court jurisdictions stabilize may straight to litigants assess odds of winning, boosting to Senate Boston certain attorneys take initiative to restructure within jurisdiction, judging tribunal which odds are such as general court, the result of forum shopping is adjudication for issues, general court space, additional time and effort on issues were not for a specialized court win about. But second, solvency. The counterpoint alone solves the case better because it's faster, more predictable as expert judges, etc. The firm undermines that through overlapping jurisdiction, which means most cases end up in Article 3 courts. Number 9, a specialized court should have complete authority over the subject matter placed within jurisdiction. It should not share jurisdiction with general courts. The concurrent jurisdiction is likely to encourage attorneys to engage in forum shopping to locate the court that is most likely to aid an issue of finding that favorable to their case where attorneys have option of forum shopping. The advantage of creating specialized courts are forfeited. The counterpoint alone avoids both claims since forum shopping is impossible without legal duties for AI established in Article 3 courts. Now, purview the counterpoint and severance. 1, a legal duty requires standing and force in Article 3 courts. That's SCOTUS. Preferred. It's from SCOTUS, the gold standard for legal definitions, which means their indictment about Clarence Thomas does not apply. You should prefer definitions coming from current Supreme Court justices over their 2015 definition. Second, the creation of a duty necessitates a right for injured parties. Burden 10, if a landowner has a right, non-owners have a duty to respect that right that focuses on the relationship nature recognized having the right and duty. This makes against human beings no longer have permission to act in a certain manner. That right is enforced in Article 3 courts. Void 19 within U.S. jurisprudence. 3 levels of legal rights and emergent legal rights. Standing fundamental all legal rights and standing parties right to make a legal claim. Standing is a legal prerequisite to any legal rights based over the threshold right to act for Article 3. 3, personhood requires enforcement of the courts. Only 19, legal person. The key feature of legal person is legal rights and enforced rights through the courts. The counterpoint uses agencies, not the courts. Bow 20, not Article 3 adjudication. Tribunals part of the executive branch will be locally called some of them legislative courts in the constitutional sense. They are not federal claims are not courts in the constitutional sense. 4, disputes over legal duties and corresponding rights require a trial by jury. That's a 7th Amendment guarantee. Ohio Southern District Court 21, bankruptcy court, black jury trials, the 7th Amendment provides right of trial by jury. Individuals are guaranteed the right in Article 3 court when legal rights are taken Congress on have legal way to entrust claims on Article 3 court. Article 1, courts are judge run. There's no jury. Howard 5, a specialized court created under Article 1, legislative power of Congress, unlike Article 3, charge right. The case states are tried without a jury. 5, the counterpoint does not vest. That's an Article 3 granted power. Lost in 6, vest from 18th century onward, strongly indicate Article 3 power vest. Grants power to Article 3. 6, prefer our interpretation. A, legal precision. Only we have evidence connecting legal duties. Article 3 courts reward specificity. You should assume their author wouldn't include the counterpoint under their definition of legal duties given our conclusive evidence. B, their evidence does not apply. It just has to be by law, but all of our evidence contextualizes that further and says that when they say by law, they mean within Article 3 courts, and that's the best interpretation, and our evidence is more qualified. C, net ground standing is the foundation of all net ground. Their interpret means that the neg loses nearest person and spillover. Since GAF does not need to grant standing to non-humans, it opens the floodgates to regulatory acts that explode limits and decimate net ground. D, topic education, court enforcement of legal duties is a core topic controversy and the foundation of AFF solvency mechanisms. Now, the intrinsic permutation, it's not going to work in this debate. First, it completely severs the AFF, including the word all, means that patients will not have standing to sue AI in the courts. That is how they describe their plan in 1AC cross-ex, and this perm bans the plan. You should not allow them to ban the plan and sever the entire AFF because it allows them to shift out of all negative ground and do AFF conditionality. Second, it doesn't solve the net benefit. The counterpoint decreases clog by removing medical AI cases from the court. The perm would decrease clog in another area, broader AI cases, but still increase it massively in the medical AI area if it does the plan, which at best maintains current levels of clog but can't solve the forum shopping over the specific plan. Second, the perm is also massively intrinsic by including the word all. They're basically fiating an additional plank that bans forum shopping, which isn't in the plan or the counterpoint. That's a voting issue. Functionally intrinsic permutations allow for word scramble permutations that the AFF can deploy to fiat out of DAs. They justify third, the counterpoint is also textually intrinsic because the word all is not in the counterpoint. And 4, the counterpoint is textually and functionally competitive. We meet their standard of competition, so their perm has to be 2. Now, the solvency debate, do that here. The counterpoint solves better than the plan. 1. Article 1 tribunals are faster, have specialized expert regulators, and create predictable adjudication that's null. And 2nd, generalist courts would be horrifically bad at enforcing the plan. Litigation over the plan would be extremely complex. As they said in 1AC Crossix, there are a ton of confusing medical questions of like who is at fault, did AI breach a reasonable standard of care in medicine, etc., that juries and judges and general courts would not be able to understand or decide effectively, making AFF enforcement a coin flip that undermines certainty. AI liability should be determined by administrative tribunals, not general courts. Malika, 22, to protect people from faulty AI, while also promoting individual liability. AI should be litigated in special courts and expert adjudicating AI cases. These specialized tribunals develop expertise in review areas such as AI specialized courts are not new special courts are connected to childhood vaccine manufacturing decades by adjudicating vaccine injuries, developing a deep knowledge of the field. 21st century AI demands the 21st century liability system. They say it's a new procedure. There's no procedural uncertainty. Gramsci 13. Court specialization is rapidly growing trend in the U.S. The trend has been creating specialized courts and tribunals, which appears to be improving access just as well. And GS disadvantaged groups specialized. It best promotes business confidence. Gramsci 13. Court specialization important to advance the successful system. Court association useful to address contract enforcement improvements and investment clients. Exceptional association helping cases that are complex cases could be handled differently, such as business cases. They say discovery key. This proves the counterpoint solves. The counterpoint does allow AI to be a part of the discovery process. It's a nearly identical process as the F. It's just not in the courts. Now do the net benefit here. Only the counterpoint resolves court backlogs by moving medical AI cases to the executive branch of the plan, and the firm allow medical AI cases in general courts, opening the floodgates to massive litigation that clogs the courts. Court clog causes data protection cases to get cut, which decimates consumer trust in the grid since there's no enforcement mechanism for privacy. That devastates broader grid security, which causes accidental grid failure that produces disease, famine, and societal collapse. As Haley Sideup and Monarch and they say the AFF is the state. The AFF has to be at least the federal. They could include state, but they can't be only the states. U.S. means national government, not the states. Anderson 55 U.S. PM. Secretary has a national unit of government. The government is recognized as state government and constitution separate from states means the federal government. Hill 9 U.S. is a legal term for federal government. Constitution authored death. They intend the meaning of the United States to be separate and distinct from that of the states, and people prefer it one net ground. Most DAs are federal, even spill over like fetal personhood. They decimate all that by making their AFF the state. Second is education, because we should be learning about the federal court process. 3, no offense. You just need to have a federal court key warrant or talk about appeals. Also, even if they are the states, they still link because there will be appeals to federal court, and they will clog data privacy cases in the states. They say theory that picks are voted. The counterpoint is not a pick. It doesn't do any of the topic. The counterpoint is good. First ground. Every element of negative ground relies on making the AFP the courts. It's the link to spill over right streak unnecessary for nearest person. Counterpoint. Second, functional limits. The topic is huge. First, they have to defend the court's key. Narrows the range of viable firms to make preparation impossible, and they should be able to defend it because they said in 1AC Crossix that their app was the courts. I'll do condo. 1, NEG flex the ability to read multiple counterpoints and kick them levels the playing field against outside bias. That's important because NEG is always reacting to app choices, which makes total versatility key to fairness. 2, argument innovation. Only conditionality gives mayors a safe net to test new strategies to spill locks and NEG in their favorite generic. It can't solve their offense because we'll add permutations and choose inevitable. Because if under highlighting, reject the argument, the judge is referee, not a norm setter, and prefer reasonability. Yes, grid collapse, manhunt 20. Tech build on another, so the system depends on system propagates critical dependence, destroying ability to back up its lost system fragility, increasing the point shock sufficient for total collapse. Mark that card at collapse, and what I have, 245.
I'm pretty sure you have more.
I think you had like
345 maybe? Yeah, I think 345. Okay. We're gonna take part.
Okay.
Okay. Okay, 255.
Okay, we have 11.
Awesome.
My first question is, we read evidence that there are judge shortages that are clogging courts now. How does the counterplan overcome that if it only redistributes the plan's cases?
There are judge shortages that are clogging. Yeah, so our argument is that like there is court clog now, we agree with you. One reason is judge shortages. Like that is why clog is occurring, but moving cases away can alleviate some of that
But you
clog.
only move new cases away. Like the Haley evidence is about why court clog is bad. Like, why does the counter plan alleviate the problems that stem from judge shortages if it only moves medical AI cases?
Well, there are existing medical AI cases that the counterplan moves away.
Okay. The perm do both argument, if it's true that courts are clogged now, based on what you just said, then why wouldn't attorneys bring their suits to tribunal courts if they're available for suits?
Yeah, so I think there's like multiple reasons. One, like the main one is forum shopping. Even if like there are some like clog issues in specific courts and there might be like a longer wait for the case or whatever, if someone thinks that they are more likely to win in a general court, they are going to go there.
Yeah, I know you've read broad evidence about
Yeah.
that psychology, but why is that true in the context of the app? Like, why is it true that attorneys will perceive like generalist courts better than like specialized courts?
It could be like about like specific judges in general courts. They could like maybe they lose a case in the tribunal.
Rather like their client wait for years for redress than try to take it to a.
If they think they're more likely to win and if they think they don't have a good chance to win in the tribunal, then yes, there is a scenario where they're willing to wait. And also just because if there's like court clog, our argument on court clog is that they cut data privacy cases, not that you have to wait for years.
Okay, we stopped it at 9:30.
Okay. The order is the Article 1 counterclaim. Nearest person, fetal personhood, the K, innovation, trust.
One more time.
What was that?
What's the order?
The Article 1 counterclaim, nearest person counterclaim, the fetal personhood DA, the K, innovation trust.
Okay.
Emory? Mike? Yep.
Article 1 counterclaim yes link ready person to destabilize the court with a lot of petitions from a small parties to FOR 22 ruling being accepted to truth would have the enormous destabilizing impacts ready person to non-human rights significant implications for all life and no standard to determining how or entitled to a standing reclaims on the non-human's behalf. Courts are facing great difficulty resolving the inevitable flood of petitions such to transform habeas into a rather confusing case-by-case injuries determined by some subjective amorphous system grading person would not be incremental and sweepy that would invite considerations by others to accept like a person beyond living humans. It's not a matter for the courts. They say render evidence is saying one specific bill doesn't lead to clog, not that clog is generally possible. Render 20 citizen enforcement of the Involvement Clause or is reason to be efficacy of the CMP rule opening the floodgates that is especially important in the moments incompetence to the nearest person counterclaim. It's conditional. We're not going for it. The fetal person to DA conceded fetal person at a time, no offense. We're not going for it. The precision item will be answered on the innovation advantage. The critique. Tweezy dropped the ball on the K. They did not read a single card defending the efficacy of training models for medical AI. That ensures the F creates a new, more insidious extension of the existing biased medical system. When black people go to the doctor and feel substantial pain, doctors prescribe different forms of treatment due to bias. Black people have a eugenic ability to withstand pain. Black pregnant mothers are more likely to be denied treatment when the pregnancy becomes a risk. Each of these examples will become worse algorithmically. Crossix wouldn't tell you how AI is trained, so I will. The input to existing medical AI's electronic health records. These are usable because they are only provide information to an insurance company about a patient for payment purposes, not care. They're explicitly racist. First, those forms do not take into account social and economic context of a particular medical issue. Second, the app only gets complete medical pictures for people who are white and healthy because those are the people that are more likely to have a consistent provider with a complete health record used for AI training inputs. The app thus makes it impossible to challenge racial bias because AI will take that subjective data as fact and use it as a universal system for diagnosing examples. A human can look at a potential organ recipient, see their life expectancy, and reason that person needs a transplant. The algorithm will say that a black person who has a statistically lower life expectancy should be prohibited that transplant to maximize utility for a person who's expected to live longer. Another example is how black children will be more likely to be diagnosed with ADHD because AI can infer from a statistical generalization that ADHD is genetically black. They've defended precision medicine. AI will attempt to be so precise that it'll include inapplicable correlations between characteristics associated with race. The 1AC evidence also says that AI can use speech pattern recognition. That's inapplicable because black people often use different tones, inflections, and definitions. Unequal accessibility to healthcare means that data sets for training AI will be unrepresentative, meaning an AI is comparative for medical data, but will be a rich white person. And the 2AC also said medical imaging on case. That's even worse with AI. AI assumes race where doctors don't and can't, like radiologists using digital-only body scans that makes them uniquely likely to perpetuate racial biases. Kennedy 22. AI can accurately predict race, but clinicians cannot do the same, indicating significant risk for AI use in healthcare models, exacerbate health disparities. Research has shown ability of AI to detect a person's race using medical images is well documented, but there are no clear proxies that would allow clinicians to do the same. Clinical radiologists cannot identify race patterns and identical models predict race are not obvious to humans. AI models perpetuate disparities in healthcare. The reason these are explicitly worse is because the AFF makes all existing inequalities seem morally neutral because AI is perceptually objective and fed with quote-unquote raw data. Each of these things that way in terms of case people will not trust a system that's only built for half the population. In turns trust as racial biases unfold. Everyone will reject it. We're creating an AI winter. It turns innovation. Every medical solution they come up with is narrowly tailored, so it's inapplicable for the vast majority of patients. They say framework, interpretation. The debate should be about the ideological commitments of the AFF, not its consequences. The AFF is not just a plan, but stated and unstated assumptions that justify it, which means the negative should get links to the AFF's assumptions and scholarship prior to weighing consequences. Plan focuses bad, lets the AFF win despite racist assumptions, and the plan has good consequences. That discourages debates over the assumptions and discourse of the 1AC, since they are unique. Racism sustains itself through narratives that entrenches racist systems as natural and inevitable. You should refuse to participate in a racially biased healthcare system. It doesn't matter if they convince you of the good consequences. That's no better than saying that we should buttress a northern slavery economy by accepting black suffering. But their framework ensures that those narratives are never challenged, directly shaping subjectivities, political orientations, and policy outcomes. No fairness, impact, small imbalances are inevitable and inconsequential given the massive ramifications of colonial education. Turn our framework leads to better and more nuanced clash by allowing interrogations of the absent assumptions, extinction versus a new leak, and necessitate sacrifice of vulnerable populations. Santos 3. West suspended the illusion that safety humanity by destroying part of it. This is how it was under colonialism with the genocide of indigenous peoples and the African slaves, and now today this is how it is with neoliberalism, the collective sacrifice of the periphery of the world system. That there is death in the third world. This is the result of market failures. This political logic aims to infinitely reproduce the status quo idea of blooming collective suicide. Death try to take some reforms of discardable populations to the concept of collateral damage and hegemonic powers legitimize the most shameful violence in the name of future. They say robots better, and above 2AC Woods is not about medical AI. It doesn't have a warrant bias. AI is worse than with white doctors. Scholar. And 22. AI can propagate racial biases leading to misdiagnosis, insufficient treatment of prescription patients, and even know if they've been enrolled in healthcare algorithms influencing care. Poorly structured AI training data set is worse than a human with a medical degree predicated on lessons learned about the health of primarily white patients. They say permutation to both is mutually exclusive. The AF embraces innovation. The alt rejects it. We've read links to the plan that the AF literally makes racial disparities worse. So it's a DA to the perm. The alternative is a refusal. Interrupt the academic narrative supporting AI. It is a necessary first step for challenging racist AI assumptions. Refusal generative and can spur academic interrogations of our commitment to racist AI. That's the CAD evidence. The lead turn is answered above. The plan generates no recourse for victims of racially biased AI. It's an inevitable consequence of a discriminatory medical system, and they put the burden on black patients to sue racist robot providers just to get to ground zero. That's unethical, especially when black patients are inevitably under-equipped with time and resources to navigate the judicial system. The AI reduces biases card is bad. It's not even about medical AI. They have one line that mentions cognitive biases, which is answered by the evidence above. The other stuff and the rest of the 2AC AI good things were way too blippy to deserve an answer. The last thing is performative contradictions. We're not. It's an if-then statement. If the app adequately defends AI, presuming it's good, then the counterplan is consistent. It's a logical extension of conditionality, and there's no in-round abuse because we can't make cross-applications the innovation advantage. Precision medicine is high now and inevitable globally. It's witnessing rapid growth that will be soon integrated as a standard approach for disease prevention. That SkyQuest is the newest evidence and is predicted to by AFF is key. SkyQuest in 823. AI is becoming popular in precision medicine. A great demand for PMs contribute to AI in the precision medicine. The precision medicine market is expected to grow to 3.4 billion by 2028 due to growing demand will drive innovation in PM health advanced medical discoveries. The hedge impact, no hedge impact correlation. You don't want that? Okay. Trust advantage. AI products failed. They've developed using the failed test attack mentality, discriminated against minorities, and all their evidence is based on AI companies self-reporting success. They intentionally avoid peer review to escape necessary criticism. That Sabo knew in a Berisha failure was the case. Accidents cause widespread disinvestment. That Sabo data is loaded with error makes treatment failure inevitable. Sabo in 19. Produce false alarms for every correct result. Any benefit may have been diluted by overdiagnosis. False positives on patients by probably doctors who withhold recommended treatment. Studies show software with the results in the lab can found when tested in real time. That's because diseases are more complex and the healthcare system far more dysfunctional. The computer scientists anticipate developers are health workers, but developers are unaware. The building on top of deep broken system electronic records are developed for building, not patient care, to filled with mistakes and missing data. Investigation found life-threatening errors in patients' medication lists, lab tests, and allergies.
y'all pick?
No.
Oh. Okay. I have 12. I sent it. So Thor's trust, the innovation advantage, then the counterplan, and then the kit.
What was the trust order again?
What's that?
Innovation trust.
Sorry, trust innovation.
Trust innovation.
Is anyone not ready? Cool. Lethal existential pandemics are coming now. They kill us all faster than the alternative can blink, which proves we outweigh on time frame. You can only die once. We have evidence that SARS, Ebola, and tons of other pandemics have already reached the threshold for extinction, so it's only a ticking time bomb now. There's no accidents or failure. The McNever evidence in the 2C says that AI and the status quo has advanced precision oncology and ecotoxicology, which allows the doctors to code for proteins and specifically prevents starvation inclusively. The cancer scans prove precision accuracy of medical AI. The standard error is less than 0.02 in a t-test to human diagnosis, which means that it's all inevitable, even in the world of the alternative. The SAB-19 evidence and the one in our, it's an analyst at Health News has no qualifications. Rigor 22, a political analyst, again, has no business talking about medical science. Now, all medical AI bad uniqueness is for the affirmative one. More innovation solves and proves that advantage one is the reason why we control uniqueness for bad AI. Two, liability checks. The only thing that the plain text actually does is it influences a liability regime for that AI to be held eligible, which means that more bad AI in the status quo is the reason why you should vote out. Now, the innovation advantage precision medicine is not inevitable. The evidence is from SkyQuest, whatever the fuck that is. Growing demand is not happening now in the context of the United States. It doesn't solve globally because our internal links to U.S. hegemony and readiness, which means it hasn't actually proliferated into the military. Strong U.S. hedge prevents fast nuke wars with China and Russia. They've conceded the internal link and the impact. Only we have 22 evidence. Both those revisionist powers also circumvent the alternative. Even if we don't solve it, it impact turns the alternative and their framework arguments about ideological commitments. Hedge, decrease child mortality, decrease international wars by 80%, civil wars by 30%, and decrease in broader violence by 20%, which proves that we will defend our ideological commitment beyond medical AI, which is something that the alternative does not solve. Now, the counterplan permutation do both. One, the net benefit zeros forum shopping. If it's true that Article 3 courts are so incredibly flooded that they can't handle another case, all the cases would be tried in the tribunal system of the counterplan. Two, plaintiffs would not forum shop. None of the evidence substantiates this rant by Michael. Patients could also bring cases to the tribunal if the net benefit were true. Case backlog mean it would be too slow, so patients would always go to the counterplan's mechanism. Three, perms don't need net benefits, otherwise being the plan competes, which destroys affirmative ground. Four, second, the solvency argument is not about tribunals. It just says that courts shouldn't share jurisdictions. That doesn't assume the net benefit. Now, perm do the plan and create a tribunal to cover all decisions related to AI. First, the plan would clarify the subset of medical AI medical now have a legal duty to care, and then the U.S. Congress would determine that all cases involving AI go to the tribunal, not the courts, which means it would override the plan in the sense that since medical AI is AI, those cases would now go to the tribunal, not the courts. Now, it's not intrinsic. One, all is not in the perm text. You misread it. We just put it in our explanation of how the perm would work, but we obviously didn't write the text like that. That obviates 99% of the 2NC on this perm. Two, counterplan is not textually or functionally competitive. Also, the perm does the whole plan, which proves that it's legitimate. Three, no terminal impact. Functional limits on the topic prove the same ground regardless of if we implement this. Four, it doesn't ban the plan. The follow-up process just changes the implementation and the enforcement of the plan. They don't ban the object of the plan, so the perm doesn't either. Now, the discovery process is key. Or perms solve most of their offense or any risk that tribunal doesn't solve is the reason that you vote after evidence is hyper-specific. The Duffer 1AC card specifically talks about the core process. Discovery is not possible to tribunal. It makes comparative arguments to other systems and says it's not possible to implement it if they fiat it. The perm is more legitimate. Now, the U.S. is federal or states. 1AC process did not specify which court. If we win at the U.S., can also mean collectively the states without the federal government. You vote affirmative on presumption or perm to the counterplan because the plan doesn't go through Article 3 courts or other state courts regardless of duties definitions since they all assume federal legislation and is the reason the counterplan competes and links to the court called no benefit. That's the 14 evidence. The U.S. means states. That's by law 18. The
makes competitive otherwise, as well as hundreds of other legal federal process counterclaims. No last that have answered the state's counterclaim superpowered uniform version steps all offense to mute core topic picks the core controversies. Who has rights now? Who gives the rights to community? Explicitly rejected federal government. The wording, the 2NC Anderson evidence is literally from 1955. The guy died 30 years ago. It doesn't assume modern U.S. Code 2NC. It'll only clause that his name is Jonathan. It doesn't cite any law or qualification. Solves ground and education. You still get stating ground. Topic education in just different ways. Only adds one mechanism, which is 50 states acting together. Read core process. It's better for net ground because you can cut a single state CA or counterplan pick out of any state or counterplan with. The federal government solves functional limits, right pick, solvency, spillover, topicality. Also have no evidence appeals would occur. The plan is durably fiated, which means the president is applied in the state court. Otherwise, the U.S. the AFF would always lose the circumvention. Competition is distinct from theory. Will concede that they get picks and infinite conditionality. It means that negative flexibility is obviously solved by those theory arguments, and there's no reason why they need this. Our grid evidence is better than theirs. The collapse is impossible. Our evidence from 2022 says it's too stable. Courts are clogged now. Now our evidence says AI is stabilizing the docket. Now the K, the 1AC does not force black people to go to the doctor. They've ranted for 20 minutes about why random issues with how we diagnose ADHD. There's no evidence AI causes that. There's no causal explanation of why the plan results in it. There's no uniqueness returns case. AI is inevitable now. Both sides have agreed. You just can't sue it. The plan makes medical AI legally liable for harm to patients. The plan ensures people can bring lawsuits against harmful medical AI, which was the plan does not make it neutral or inclusive things, and it can't turn the case. Now, framework debate should not be about ideological commitment, which impact turn their view of the medical system in the world, which means we so went on case even if we lose framework with what you see against a pandemic opportunity cost or interest wasn't just plain focus, just that you need an alternative that engages in cost benefit analysis. First impact is clash. Their model just incentivizes targeted research and confronts it with an academic vacuum, muting the 1AC first shift to unpredictable questions to attract targeted and rigor. Fairness outweighs the negative burden of rejoining the role of the ballot is arbitrary and self-serving because you lose framework is legitimized because it holds the F to a standard of epistemic perfection where they point out one bad assumption and when small imbalances are procedural, which proves they outweigh on scope. The F is not racist and voting NEG doesn't change the system, so it can't outweigh. There's no net benefit to their interp. One, it justifies ad-homs and work picks out of random price in the cards, since it will all be assumptions of the debaters and the policies, increases community violence and burnout. Two, requires the content of debate shapes subjectivities impossible to which our debate extinction outweighs disease myths their impact. Our argument is Utah should not always be evoked with no consideration for surrounding impacts, but rather the magnitude of pandemic supersedes all impact. Mass disease spread outbreak is the only actual argument for ultimate form of structural violence and wipes out future generations. For abstract moral purity, permutation, do both. We do not need to win the entire, we don't need to do the entire alternative, just the parts not mutually exclusive. The plan is not fiat, anyone goes to the doctor. All bad AI could be banned, and AI that's used to just predict diseases would be caused by the plan. There's no causal link to any other impacts. All their evidence is status quo descriptive that algorithms are failing now. Because they don't solve mathematical AI, how do you stop people from using Siri, charting systems, etc.?
Okay, 2:55 start now.
Yeah, I can do that.
this one.
Go for it.
Okay. Just a counterpoint. Everyone good? Alright. We're not going for the K, it's conditional, going for the counterpoint. They needed to extend perm to the counterpoint in the 1AR. The counterpoint solves better than the entire case. We have won massive amounts of arguments that generalized courts are terrible for solving the AFF. This is a massive solvency takeout to the AFF, which means that their case impacts have now become impacts for the negative, because only voting negative is able to solve for the impacts of the 1AC, which they have said are existential, like hegemony, disease, etc. Generalized courts are not able to solve medical AI decisions, and the cases are extremely slow because there's massive court clog within these generalized courts, which means that it takes too long for people to get redress for medical AI, which undermines trust in the medical AI and all the 1AC's internal ways. Additionally, general courts are decided by juries. These juries have no expertise on AI. They do not understand the content of these arguments because it's extremely confusing. Trying to get a jury to decide who was at fault, was it the doctor or the artificial intelligence? Did it breach a reasonable standard of care, which is an extremely confusing part of medical law that most people are not able to understand. And whether or not the AI had agency, they don't understand the AI technology itself, which means that it is very hard for them to produce good decisions over this. That produces an inconsistent patchwork of decisions over the AFF within general courts. That means that litigants have no certainty of whether they will win their lawsuit, and even providers of the medical AI don't know whether or not they're going to win or lose any given case, which means that they can't develop standardized practices for how they want to implement the medical AI. That means which means that they are not able to solve the case. Only the counterpoint is able to solve better. The Malinha evidence says that creating a specialized tribunal for AI liability cases would be faster and would use subject matter expert judges that are able to produce consistent decisions and precedent. It's also better for business certainty as per our Graham evidence, which means it leads to better hospital uptake of AI, which is the key internal link to their first advantage, which proves that we are able to solve the case better than they are, and that is an independent net benefit. Now, there's also a court clog net benefit that is also a DA to the perm, because any more cases over medical AI going into the generalized courts will lead data protection cases to get cut. Now, perm to both is not able to solve either of these net benefits. If we win any risk of forum shopping, that any cases go to the generalized courts, that undermines our entire net benefit, because it leads to a confusion over which cases and leads to lack of a uniform precedent, because there will be different precedents in the general courts versus the Article 1 tribunals, which means that people cannot trust it, etc. It also leads to clog, because any cases going there will lead to a cut of data protection cases, and you should see this as a linear net benefit, given that the AFF has no offense. Now, there will be forum shopping first. Not everyone knows the best place to go. Our evidence says that people are likely to go to general courts because that is seen as the most general forum for producing liability cases. Second, they will forum shop to try to find the best judges or the best conditions where they think they are most likely to win the cases, because they might perceive Article 1 tribunals as not good for their specific case. 3, our argument is not that courts have massive year-long backlogs in the status quo, just that they will cut data protection cases, which means that people will go to the general courts. Data protection will be cut, triggering our net benefit. And they will do that. They will not all, you can't trust that all thousands of these cases will all go to the Article 1 tribunal. A lot of them will go to the general courts. Now, quickly, I'm going to answer this discovery argument. It does not apply to the counterpoint. The counterpoint is an identical process to the two courts. It just happens in tribunals established by the legislative branch. Our Graham evidence says it is procedurally identical to the courts. It does the same discovery process, and it allows AI to be named as a defendant. The only difference is it happens in the executive branch with specialized judges instead of juries, which means it solves the entirety case, and we have offense on solvency. Now, only 2 more things I need to answer. First is the intrinsic and severance permutation that they extended. First, but even if you don't put it down on theory, it does not solve our net benefit. They say the word all in their explanation, they're right, but not in the text, which means that they can't solve the net benefit. This is functionally a perm do both, because it does the plan, which leads to litigation in Article 3 courts, and then it says artificial computing system cases will happen in a tribunal, but all of our forum shopping answers still apply to that because litigants still have the ability to litigate in Article 3 courts post this permutation, which means they still will, and it still triggers both of our net benefits. Independently, this is severance. They said quote, this overrides our plan because all cases go to the tribunal. If they are right about this explanation, it means that they clearly sever the plan because post permutation, litigants would not be able to sue in Article 3 courts, which is how they describe the plan as occurring in what you see cross-ex. Severing that is a voting issue for AFF conditionality. The permutation is also intrinsic because it does something not in the plan or the counterplan, which is creating a tribunal for all artificial intelligence. Those intrinsic permutations lead to word scramble permutations that allow them to fiat out of net benefits and decimate net grant, especially when they have conceded the counterplan is good on the theory debate and that conditionality is good. You should not allow for that. Now, the court clog net benefit is largely conceded. Grid collapse will occur because they are all connected as per our Mannheim evidence, and that will cascade and cause societal collapse. The counterplan is able to resolve court clog by moving cases out of these courts, but the AFF leads to a flood of personhood cases as per the D4 evidence that they would not be able to manage and would lead to data protection cases getting cuts as per our Haley evidence. I will agree with them that their AFF is the state, but we have a great argument that cases being litigated in the state will eventually be appealed to the federal courts, even if that's not a fiated mandate of the plan. If there are cases in state courts about medical AI, it would get appealed in federal courts. If someone loses a case, they're obviously going to try to move this up the ladder to federal courts, even all the way up to the Supreme Court, which still guarantees some level of court clog, and this doesn't implicate our solvency net benefit anyways.
No,
How much time?
we have like 5 left.
arguments in the 2-and-R, reject NEG sandbagging and perm reclarifications, destroys 1AR strategic choice. Now the line by line. Importantly, both perms solve any reason why the counterpoint is better than the AFF in terms of double solvency. The 2 and C and 2-and-R only explain why the perms don't solve the net benefit, but not why it doesn't solve the case. All the arguments about how the general courts are worse for medical AI and the tribunal is better at deciding these cases is irrelevant. Also, when we are going for the fact that the U.S. is the states, it means that there is no offense about state courts that was in the 2-and-R. The forum shopping argument does not apply to either arguments in the 2-AR. Their evidence is hyper-specific to people going to the court instead of the tribunal because they perceive Article 3 courts as insufficient. They have no evidence that state courts have those clogs, and the other perm overrules the enforcement of the plan on the counterplan. I'll go to what they're calling the intrinsic perm. It's neither severance nor intrinsic. It does the entire plan and mechanism. The counterplan then comes and just clarifies how it's implemented. The entire 2-and-R here is brand new. They misread the counterplan text in the 2 and C and paid attention to the explanation that was in the doc instead of the text itself. We say all in the explanation. We said it clearly in the 2AC. They also re-explained their counterplan beyond the text in every speech. Obviously, 10 seconds doesn't describe the entire mechanism. The plank of the counterplan does not ban the plan or overrule it. It's not severance. It doesn't eliminate the plan. It simply re-specifies the other part of the counterplan. We still do the full plan of the court system. The counterplan then comes and advances the nuance of the enforcement. It's not intrinsic. Again, it doesn't ban the plan. The follow-up process just changes the implementation and enforcement of the plan. They don't ban the object of the plan, so the perm doesn't either. They have no offense either, even if it is intrinsic. They drop the ground outweighs. World scramble perms are solved by smart 2 and text writing. For example, the DeVest counterplan demonstrates this because it actually bans the object of the plan, so you can't perm it, which proves that we solved net ground. The DeVest counterplan text holds the act is unlawful on the grounds that there cannot be non-human legal persons. That obviates the potential for word scramble perms. And proves that the sort of perm we're going for does not inevitably doom the NEG, but it does let the app take advantage of bad counterplan text writing. Now, ground outweighs. First, debate is an arms race. The app must constantly innovate to keep up with expanding set of arguments in the next arsenal, especially as we're approaching the NET. Otherwise, teams are disincentivized from doing innovative research, which stagnates the topic's evolution. Second, independent of the topic, the NEG is structurally ahead, given the block conditionality, which we have conceded they get an infinite amount of topic arguments. Their model of combination occupies the side divide. Fairness outweighs. Competition sets the terms of debate, which controls the internal link to all impacts. Limited intrinsic perms are important. Otherwise, the app always loses to artificially competitive, terrible counterplans. Functional counterplans. Allowing nuke Russia if we do the plan or any other silly variation that only competes because the NEG has used FAOT to make it compete. Their interpretation denies all political reality and the benefits of cost-benefit analysis yielded by clash over opportunity cost, which is the only true intrinsic benefit to policy debate, as opposed to reading a book or a speech event. Functional limits on the topic solve NEG ground considerations. Infinite condo, endless advantage counterplans. To pick solve on a topic without a semblance of its duties or personhood keyword. The core controversy of the topic is whether or not an entity needs to be granted rights, or what entities are being granted rights, not who is doing it. The best negative argument on the topic is the rights pick counterplays that change liability, no fault insurance, human right to nature, advantage counterplays, etc. And this bill over DI all prove that the NEG is good and final. The topic doesn't mean this counterplan after considerations outweigh.
Anything else?
No.
Okay. Good debate.
Good debate.
Good debate.
Do you want us to send the perm text or?
I mean, yeah.
Good debate.
Could you just reply with the perm text?
Yeah.
Oh, is that the thing you sent an hour ago?
Yeah, I sent it in the chain.
Okay, then you're good.
Okay.
Can you all send me a doc?
Yeah.
Yeah.
Yeah, Danny, this is about, is it no, I'll explain that. No, this is asking me to change, so
Okay, I sent the NEG doc.
Thank you.
Thank you for judging.
yeah,
You're
thanks.
welcome.
And great debate, y'all. Good luck.
You too. Good luck. Okay, I think you can say it. I don't think they're all.
Like, don't do that.
Okay.
I feel like we shouldn't use it.
One. Okay.
But those are like.
I just read these in the logo.
Thank you.
Thanks, Becky.
Yep.
That's what we're doing.
That is literally my only thought. And then like, we should keep things like fairly clear as much as possible.
Let me just read because Dan is saying.
Disclosures at 2:30.
We are. Sounds good. 6.
Okay, so they do not straight transfer over. They think they're straight transfer.
Oh, well, are we not reading it?
Dan wants us to read more dissets, less condo.
Okay. Yeah, I mean, they think it's a straight turn. They very much think it's a straight turn.
Can you like explain why it's not? And then Grace will kick out of it, so you'll have to.
They don't have a person in a key card. We should read cards on it though in the 1 hour for sure.
Could you help with that?
Yeah, 100%. Just follow their TVC for their Texas.
Yeah, who have they been up against? Texas and Georgia.
Oh, sorry, yeah, Texas and Georgia. Yeah. And when you say spillover, you mean they have spillover, yeah?
About the OG breakpoint, they're gonna be very upset about it.
They're
I
wrong.
can handle it.
Okay, yeah, they're wrong. So, just they're gonna be like,
How do you
it's so
pronounce it,
racist. Ojibwe. But they're gonna be like, it's so racist. And you're gonna be like, no, you're wrong.
Okay, I'll put it right back to him.
Like the whole argument is that them calling them the Ojibwe in law is racist.
Okay, got it.
Ojibwe are from Minnesota.
Okay, yeah, I can send it.
Yeah, so one time, when I was a senior in high school, I took this Native American literature class. And there's this very large building in Minneapolis, and a lot of Ojibwe people died making it. Like a lot.
So bad.
Like a lot of them.
That's so sad.
Yeah, I know. No, they've had it rough. They've definitely had it rough.
Wait, why do you not want us to read that?
Too many content.
Wait, but we took out divest, so now we just.
Why did we take our divest?
Yeah, I think that we were on key investing.
The problem
Keep
is that
divest.
both conference ban the plan, so like, you can't extend
Which is the second counterclass that bans the plan?
delegation, remember, from that
Yeah.
time?
It bans the
One
plan in a
lands
very
the
different
option.
way. In a very different way.
I don't know, it,
Whatever, just do whatever it
It's
is.
up to you.
Yeah. I agree with Dan.
yeah, I just don't think we need all of it.
Oh, I agree with this too.
Well,
I think that.
but I think if we're taking one out, we should take out the K because we're never gonna go for it. And there's a chance we could go for everything.
Good luck. Bye.
Thank you.
Okay.
True. But, yeah, I'll defer it.
I'll defer to Dan, I don't really care. Okay, so.
He thinks 3 condos dicey, we should only have 2.
I kind of agree with that.
Okay, then,
And Calhoun is secretly amazing for condo.
so then what are the 2 we wanna read? I think
I
divest
think-
is really good.
Yeah, I think
Sorry.
divest and, the trap reports.
So we don't wanna read the Ojibwe pick? Why don't we just read the net benefit to the Ojibwe pick on the case?
Yeah. Okay, yeah, there you go. Great.
Make it a DA.
It's a gateway issue.
No, that's actually really good, cause that is a good answer to their like frame and stuff, it's like, hey, you're fudge table.
Yeah, and then, like,
I can extend
if it becomes a
and
thing,
that way
you,
they can't be like, you're right.
you can extend it, and then you can make an argument that's just like, if we disprove this part of the 1AC, you don't have to disagree with the rest of it. You can say that the 1AC was fine absent this thing.
Yeah, there you go, give them a little,
It's condo, but it's not
Yeah.
condo.
yeah.
And I would like add to that, like, any reason that they can, the rest of the case can outweigh just proves that you should put on all our usable consequential evidence.
Yeah, agreed.
Ayu, can you send me the 2NC as it is, the like?
Yeah, it's on
Yeah,
TV
just write
Grace.
it, Grace.
Oh, it is?
Yeah, we need to